Judges as policymakers. In America, judges resolve disputes, but they also act as policymakers. In order to understand how this works, we need to know a little bit more about the role of the judge in our legal system. There are a number of different legal systems in the world. I'm going to introduce you to the four major ones. First is the common law system. This is the kind of legal system we have in America. This system developed as a way to make the king's life a little easier. King Henry realized that there just wasn't enough of him to go around. Perhaps he was spending too much time sentencing people to the dungeon and wanted more leisure time to enjoy being king. In any event, a system of king's courts developed. These courts were empowered to do the day-to-day dispute resolution in the king's name so that the king could get on with the other things that a king has to do. While it's not so hard for a single person to make decisions in a consistent way, it's much harder to protect the consistency of the law when you have all sorts of different people making the decisions. This had the potential to leave the citizens bewildered, as they wouldn't be able to predict the outcome of any given case. To get around this, the judges started making notes about their cases. They provided a brief recounting of the facts, a summary of how they decided the case, and a statement of the reasons for that decision. The judges then exchanged notes so that they could draw on the underlying logic of previous decisions when new cases came in front of them. This was a clever way to help the courts be more consistent and predictable. And it's called precedent. This just means that the rationale used in an old decision should be applied to all future cases with similar case facts. It's also sometimes called stare decisis, which is roughly translated as let the previous decision stand. But we'll get back to this in a bit. First, let's take a look at some of the other legal traditions. The next on our list is the civil law tradition. This is used throughout most of Europe and South America. It's also called Romano-Germanic law. This comes from the Roman tradition of creating comprehensive books of laws or codes. The job of the judge is to resolve disputes by simply applying the code. But how different is this from the common law system? In the civil law system, the code is the only real source of policy. In the modern systems, the legislature is supreme. It creates a code that is intended to anticipate all future circumstances and provides punishments and remedies for all of these contingencies. So the judges are a little like technocrats. They don't have to be creative or fill in the blanks in the law, as the law is intended to be comprehensive. For this reason, there isn't really a need for something like precedent. The next system is socialist law. Socialist law is probably best understood as a branch of the civil law system. The civil law system was already in place in the regions where communism would evolve. The existing code-based system was adapted to incorporate Marxist and Leninist ideals. The major difference in terms of the content of the code had to do with property law. Because socialist systems are defined by their government central property ownership, the private property law in the civil law tradition was replaced entirely. In practice, socialist law was also much less concerned with providing individual justice and more interested in instructing the citizenry about how to be successful communist citizens. This changed a bit in the de-Stalinization period under Khrushchev, but the judges retained very little independence. Many of the Soviet-era judges reported being dispensers of what they called telephone justice, whereby an official from the government would call the judge on the telephone and instruct him how he should rule in a particular case. But socialist law is on the decline. After the fall of the Soviet Union, many of the countries reverted back to the civil law systems they had before. Others maintained the new system, but changed the code. But there isn't much of a difference here. Indeed, some scholars argue that it's a bit pointless to separate socialist law from civil law systems in the first place. But socialist law is important historically, so I've opted to let it stay. Our last system is Islamic law, or more properly, fiqh or Islamic jurisprudence. Unlike the other system, Islamic jurisprudence is based on divine law. This law is derived from the writings of the Prophet Muhammad, most notably the Quran and the Sunnah. The resulting law is the foundation of religious, political, and civil life. Judges in this system are called faqih, and they are trained in both law and Islam. Islamic law is used through the Muslim world, and there are many different schools. Some countries use a combination of systems whereby non-Muslims may avail themselves of non-Islamic courts. But some of the techniques of Islamic law are not all that different from the common law, especially since the judges are charged with interpreting the intent of God and the Prophet, distilling it into a set of laws for citizens to live by. Indeed, some of these techniques may have influenced the development of British common law. Here is a map of the major legal systems of the world. You can see that the countries in red are common law countries, and most of these are former British colonies. Civil law countries are in blue, and here the socialist law countries are not distinguished. Islamic law countries are in yellow, and hybrid systems appear in brown. Now, you might be wondering, but how does this explain judicial policy making? Well, it all comes back to precedent. Now you know that precedent is something peculiar to the common law system. So, the common law judge has a unique role in the system that civil law judges don't have. In this kind of system, there are laws, but the law doesn't attempt to anticipate all situations. Instead, we rely on the judge to fill in the blanks through interpretation. Imagine a local ordinance passed in 1920 prohibits the use of motorized vehicles in the city park. At the time, the city council probably intended to keep people from driving their Model Ts all through the grass. But let's say you've decided to take your grandma to the park. She's got some mobility problems, so she's riding in a hover-round. An officer comes by and gives her a ticket for operating a motor vehicle in the park in violation of the 1920 ordinance. What do? Well, you'd probably fight the ticket. The judge would be able to look at the facts of the case and make a judgment call. Does the law really apply to Grandma's hover-round? Or does the word vehicle apply only to passenger cars? In our example, let's imagine that the judge is reasonable and rules that the law allows the use of personal mobility enhancement devices. Now, this judge has set a precedent. Why is this a big deal? Well, first off, Grandma doesn't have to pay the ticket this time. But it also means that she can go to the park whenever she wants without worrying about getting a ticket. And it means that all of her friends can bring their power chairs to the park. When the precedent is set by a higher court, like the Supreme Court, it is binding on all of the lower courts too. This means that other people, including legislators, citizens, companies, etc., now know that each time the court has to deal with an old vehicle statute like this one, they won't apply to mobility scooters. So grandmas everywhere are free to roam the nation's parks. And in this way, precedent really is policy. So common law judges are policymakers. And remember that since the interpretive power of the American courts extends to constitutional matters, judges are also makers of constitutional policy. And that's a big deal.